alternative. I don't know if you're everyone laughing when you made that argument. Followed by the counter plan, politics, and yes. The argument of the 2AC of the counterclaim fundamentally links to the criticism because it assumes the Supreme Court is an object of the act of being controlled. This is the internal link to their decision impact. They've also conceded the commonly inevitability argument says this isn't a reach to reject the argument. They have conceded the argument that totalized metaphysical claims are inevitable, which means not need to decrease reject the affirmative, such in the context of permutations. And the 2 pieces of 0 and 98 evidence does not deal with these arguments. This indicates that we solve 100% of risk of the impacts. They've conceded the argument that sexual difference solves all notions of difference, which is the only internal link to objectifying people. They've also conceded that objectifying women is the key to objectifying all other forms of institutional otherization in the status quo, which means we solve the terminal impact scenario. This is a reason you should prove the permutation. They have to win an in scenario for their impact claim, which is a distinction. He has no articulation in the 2 and R as to, and the 2 and C as to why using the it-thou distinction in the context for why objectifying the Supreme Court will necessarily lead to extinction, which means there's no specific scenario. We aren't going to go for our Pick's argument of already seen in the first piece, paragraph 6 in the second piece of evidence says the AF opens a new form of language and emancipation. This also means that you can't put on the internal link to this argument because our evidence has to be changed to symbolic notion of language in and of itself, which means objectification becomes impossible. They have no reasons why the residual risk of the words in the plan would be able to overwhelm the risk of permutation solving the net benefit, which means they have to win an overwhelming risk of the impact in order to justify voting negative in this round. Counterpoint. At the top, though, we're going to go for the permutation solves the net benefit. The only internal link to their argument is consistent controversial decisions, but A has no answer in the 2 and C to our argument that if you do the counterplan and the plan at the same time, that it will never be perceived as a kind of a controversial decision because every congressperson in the entire country will also be doing the exact same thing, which means the public will be more willing to latch onto them. This means there should be no political perception in the world of the permutation because Kennedy would not care. People would be focusing on Congress instead. He says the tribe-specific overrule group all these arguments. He does not answer argument that they can't solve the affirmative claim because of the Sheehan evidence about language. He says they functionally leave the Casey decision on the Constitution, which means it's codified in constitutional law that abortion can only be regulated through the language of men, and the women are inferior to men, even if they win the overturn the provision. This is irrelevant because the Constitution still says that the legal codification means that women are inferior decision makers. Many can see this internally into our Foucault 90 evidence, which is the sexual difference argument, as well as the Airway 91 argument read on the affirmative. The impact of this is a genocide worse than extinction is societal change arguments. This evidence is terrible. This internal link evidence is not good enough on why it will be able to mobilize this argument. Also, the explicitly involved by the permutation will be able to solve this argument back, and there are only way they say the court wouldn't strike it down because of Article 5 considerations in Congress, but the court will strike those down. Wheels in 2005, court explained this claim to judicial supremacy more considered Barr's claim to judicial supremacy over federal officials who made only the context of Congress. Section 5 authority thus left open the possibility of Congress being entitled to the extension reflected to review the Constitution from that court. Morrison Dickerson will close that possibility. Morrison is interpretive supremacy is global's interpretation of the Constitution. Trump knows the political branch, regardless of what constitutional authority those branches are exercising. This is damning to them, meaning the affirmative would outweigh any of the risk of their disadvantage arguments. They say the permutation links to disadvantage. This argument says both groups is web evidence. This evidence does not mention abortion. Says other issues fundamentally Trump's argument. They also this other piece of West evidence is talking about why Democrats should preempt state governments. It's not about the abortion issue. We're the only reading about specific about the notion of abortion crossed by the Smith in 2005 and the 2AC. This is the course of the only thing they rule over abortion because they made the original decision. Group the conditionality, made conditionality does solve all your offense. The only reason you have is why it doesn't is because we're collapsing the conditionality, but you can see in competitive equity and affirmative flexibility outweigh these arguments in the world dispositionality. The affirmative gets to choose when you become conditional, which is better. And Ross applied Russell's argument before the round that at Harvard there's snake side bias because you knew you were hitting us all night and you were going to go negative, which is why you should an affirmative on this argument. Your interpretation of one counterclaim or alternative makes no sense in context of your alternative because it is counterclaiming. You also concede the argument that it is contradictory because you have two different actors. Speech can never generate offense. This is also a reason why permutation doesn't check, which means if we win competitive equity outweighs, you seal our ground, and even if the type to use inevitable, you make it uniquely worse. Which means linear impact EPA just at the top. We are going to go for our uniqueness arguments about the inevitably controversial decision. They say it just talks about partial birth abortion ban. Here's more evidence about in 2006 when the court does over one case will face whether the law bans partial birth ban in 2003 is constitutional. Of course, being asked the law is acceptable even though it's not canceled. So would be members who most likely provide key justice will be Kenny taking over the role of the swing over since retired last year. This evidence is specific to an abortion decision, which means we can functionally when there's many needs in this internally group their arguments. Evidence they read to answer this controversial argument is 9 years old. Can group their arguments for our arbitrary and illegal. Even if the public perceive our plan, our evidence is that Kennedy does not care. They've also conceded the argument that Kennedy will always support abortion rights in the status quo, which means he will stand by his political convictions. They have no no evidence that says that his perception of public outweighs his philosophical convictions on abortion, which brings we're the only team reading this internal link argument about how I philosophically recognize institutional professors of law that have studied Kennedy swing voting, and they've also conceded the argument Alito is swing vote. The only thing she says it doesn't matter because we'll fight against Alito, but this is irrelevant because Kennedy will not view his decision as controversial, which means they can't access internally because he believes that there should be abortion rights in the status quo. Therefore, he will think that he is merely standing by himself. He doesn't view him. If he does the plan, he does not view himself as overruling a decision. He views himself as affirming a decision he already made. They have conceded this argument, which means they can get no internal link to this impact. In this case, they say the hominin had no lasting effect. This proves that politics is not a consideration. If they win the argument that past terms are irrelevant, that this is just another reason why courts can skew themselves away from the public, especially in the multiple permutation. They say there are arguments about how the courts are going to rule for the states in the status quo. Our evidence assumes that this is not going to happen. It also assumes the Alito internal link argument that I made above, which is a proof that they're not going to do in the status quo. On the impact debate, they have no evidence about the time frame distinction. They say that at least more violence against women, but this is irrelevant. The only internal link they have to global warming is emissions, which they've conceded the argument that the EPA will take forever to do rulings. They've also conceded the argument that Congress is going to do regulations of the status quo, which solves the terminal impact. They have no impact comparison. They have no time frame comparison between the institution, EPA, and Congress. There's more evidence. Clean Air Report 713. A utility source staff lobbying to CO2 legislation going to do anyway, not going to concern what the Supreme Court says. Any efforts to prove an unfair regime would obviously better than Congress has been able to reauthorize even the current Clean Air Act and on conservative justice for failing environmental issues. Miscreants in 2006, just made laying the groundwork for change. Roberts, along with Alito, Scali, and Thomas, signal for desire for less federal regulation of the environment. You can be seeking fine with the court. We'll hear his first case global and global warming, which means they can't win any of these solid deficit arguments on the case group. The essentialism arguments, they conceded arguments about agency are and language argument is counterplaying answers to this argument. They say that trace off with the notion of pregnancy and abortion. But this is exactly what our argument is. You only associate a comparison between abortion and pregnancy. You do not recognize that there are women who have differentiated opinions on this, which is internally turning your essentialism argument. We also conceded the two pieces of evidence are the two we see in the case debate to answer this essentialism. He says that we can't do language and institutionalization, but that's not true. We can do both. You can see the argument. Last piece of what I see evidence is we can reorient the conservative project, and we're the only way to stop the discrimination against poor and minorities in the status quo.
314.